According to the Occupational Safety and Health Act of 1970, it is the responsibility of each employer to provide a place of employment that is free from recognized hazards that are causing or likely to cause death or serious physical harm to employees. The duties of employers and employees is called the general standard. They are: each employer shall furnish to each of his employees employment and a place of employment which are free from recognized hazards that are causing or are likely to cause death or serious physical harm to his employees, and shall comply with occupational safety and health standards promulgated under this chapter. Each employee shall comply with occupational safety and health standards and all rules, regulations, and orders issued pursuant to this chapter, which are applicable to his own actions and conduct. Industrial accident statistics in the United States are compiled and published by three major organizations: the U.S. Public Health Service, the National Safety Council, and the Bureau of Labor Statistics. Each year in the United States, industrial accidents result in more than 4,000 deaths and 5 million injuries that require a medical consultation. On the positive side, statistics indicate that fewer accidents occur at work than on the highways, at home, or in public activities. As a result of the Occupational Safety and Health Act, deaths have declined by 66% in the workplace. Safety statistics rely greatly on accident statistics that are reported in the form of incidence rates by company and by industry. The Bureau of Labor Statistics compiles incident rates for occupational injuries and illnesses from employer reports required by OSHA. An incident rate refers to recordable cases. So here you look at the formula and you have N equals number of injuries and or illnesses or lost work days. EH equals total employee hours worked by all employees during the calendar year. And 200,000 is the equivalent of 100 full-time employees, each working 50 weeks or 40 hours per week. Using this formula, the BLS computes 4 incident rates for each industry: total recordable cases, days away from work, days on job transfer or restricted work, and other recordable cases. Total recordable cases is a measure of accident frequency, that is, how often accidents occur. Days away from work is a measure of accident severity and involves 1 or more days away from work. Days of job transfer or restricted work is another measure of accident severity and involves the number of days employees are able to work but are unable to perform their regular job duties. And other recordable cases include cases that involve illnesses, injuries, anything that requires medical treatment beyond first aid. When evidence indicates that a substance poses a significant occupational risk to health, OSHA begins its rulemaking process to develop standards for regulating the use of substances. OSHA develops safety standards according to the rules established by the Administrative Procedure Act of 1946, which governs the way administrative agencies, including OSHA, may propose and establish regulations. All OSHA standards are published in the Federal Register, which is available in most public libraries or may be purchased. To help employers understand the law and how it's administered, OSHA maintains a website at www.osha.gov. Employees have a right to request an OSHA inspection if they believe their job duties or working conditions pose a threat to their well-being. These complaints can be made anonymously, or the employee can insist that OSHA maintain confidentiality. The Occupational Safety and Health Act protects employees from discharge or discrimination when they report unsafe or unhealthy working conditions, regardless of whether they report the complaint to the employer, OSHA, or outside parties such as the press. Employees have a right to participate in union activities related to job safety, such as serving on safety committees or acting in concert to protest job safety and health hazards. Employees or their representatives have a right to participate in OSHA inspections, conferences, and other hearings, and employees have a right to refuse to work if they reasonably believe that their working conditions pose an imminent risk of death or serious bodily injury. For each recordable injury or illness, OSHA Form 301 Injury and Illness Incident Report or an equivalent form must be completed within 7 calendar days. We used to call this an accident investigation or an incident report. Employers must catalog all injuries on OSHA Form 300, that's the log of work-related injuries and illnesses, and summarize the log in OSHA Form 300A, Summary of Work-Related Injuries and Illnesses, at the end of each year. The log and summary must be kept for 5 years. OSHA specifies a 3-step standard for creating a safe environment and eliminating hazards. Use engineering standards or processes first to eliminate the hazard. Follow safe work practices and training to avoid accidents, and use personal protective equipment as a last line of defense. To enforce its standards, OSHA is authorized to conduct workplace inspections. When a compliance officer presents the appropriate credentials, the employer is required to allow the officer to enter without delay to inspect and investigate. The highest priority situations are those involving imminent danger. An imminent danger is any condition where a high probability exists that an accident may occur that will result in death or serious physical harm. OSHA's second priority is to investigate fatalities and catastrophes that hospitalize 3 or more employees. After compliance officers report their findings to the OSHA office, the area director determines what citations and penalties will be issued. The citations indicate which standards have been violated and set a time limit for correcting each problem. Citations are usually sent via registered mail, but they can be issued on the spot during the closing conference, if warranted by the situation and if the area director is contacted. Citations must be posted so that everyone can see them. Now, some employers consider appealing the citations. However, it's usually much less expensive to simply fix the problem and move on. Many states have their own safety programs, and that's okay, as long as they exceed or are equal to the OSHA standards. Violations of OSHA standards can be very costly for a company. There are 5 levels of violations under the Act. De minimis, this is no direct or immediate relationship to job safety or health, no penalty. Other than serious, this is a direct relationship to safety or health, but unlikely to cause serious physical harm. Discretionary penalty of as much as $7,000 may be adjusted downward by as much as 95%. Serious violation. This is where you have a substantial probability of death or serious physical harm, and the employer knew or should have known about the hazard. Mandatory penalty of up to $7,000, but may be adjusted downward based on the employer's good faith history of previous violations. Willful violations. This is when the employer knows about it. There's an intentional disregard for a specific OSHA standard or the general duty clause. Penalties from $5,000 to $70,000 for each violation, and or as long as 6 months in prison if the violation results in death. A fine of up to $250,000 for an individual or $500,000 for a corporation may be imposed for a criminal conviction. And then repeated violations, boy, you do not want to get a citation and then do it over again. Repeated willful violations of a similar nature can add up to penalties of up to $70,000 for each violation. Also, falsifying a record can also be $70,000 and 6 months in jail. This is an example of an OSHA Form 300, and you can see here where they have logged the different injuries that occurred in their workplace. They have a lot. I've never seen one that was completely full like that. But again, if you have a large employer, I can imagine that you would. Generally speaking, in my career, I might have had maybe 3 or 4 recordable injuries during the year, but then I also generally worked in organizations that were maybe 3,000 employees, so not huge organizations. The OSHA Form 300A, the Summary of Work-Related Injuries and Illnesses, must be posted no later than February 1st of each year and remain posted until April 30th of that year. It must also be made available on request for examination and copying to any employee or former employee. A job safety and health protection poster informing employees of their rights and responsibilities under the Act is also required to be posted in every workplace. It's important to understand there's a difference between reporting and recording. Okay? Reporting is where we literally have to call OSHA. So anytime there is a death of an employee, we have to call OSHA within 8 hours. Any accidents that result in an inpatient hospitalization must be reported within 24 hours. Now, that's literally picking up the phone and calling OSHA, okay? Recording is what we put on our OSHA 300 form. Yes, we have to record every death, of course. Anytime we have a loss of consciousness, anytime there's any days away from work, restricted work activity or job transfer, medical treatment beyond first aid, any work-related illnesses such as cancer that were caused at work, needle sticks, tuberculosis, any of that type of stuff has to be written down on our OSHA 300 form. There's two terms I want you to remember: the Department of Health and Human Resources and the National Institute of Occupational Health and Safety. And the reason why these organizations are important to remember is these are the organizations that help OSHA make their determinations about what is safe and what is not safe. Often you'll hear National Institute of Occupational Health and Safety referred to as NIOSH. In 1986, OSHA issued a hazard communication standard that requires employers to notify employees when hazardous chemicals are present in the workplace and to train employees to work with them safely. Some items are excluded from the hazard communication standard, such as hazardous waste regulated by the EPA, and that's because they're regulated by the EPA, not OSHA. Tobacco and wood products, manufactured articles that do not release hazardous chemicals under normal conditions, foods, drugs, cosmetics, and alcoholic beverages, consumer products that do not result in a greater exposure than experienced by consumers in normal use, and manufactured articles that release hazardous chemicals in such small amounts that they do not pose health risks. The Hazard Communication Standard requires manufacturers, importers, and distributors to label, tag, or mark every container of hazardous chemicals that leaves their workplace with this information: the identity of the hazardous chemical, the appropriate hazard warning, and the name and address of the chemical manufacturer, importer, or distributor. Employers are required to maintain a material safety data sheet, otherwise known as an MSDS, for each hazardous chemical that is used, processed, or stored. Employers are also required to have a written hazard communication program that is available for inspection by employees, unions, and OSHA. Safety programs need the support of top management to be effective. Here are some procedures. Post the OSHA workplace poster, Job Safety and Health Protection, where all employees can see it. Hold periodic meetings with employees to discuss job safety and health matters. Show employees a copy of the Occupational Safety and Health Act and explain the OSHA standards that apply to them. Prepare a policy statement that clearly declares management's concern about safety and health. Include job safety and health topics in conversations with employees. Review all inspection and accident reports and check to make certain that hazards are eliminated. Participate effectively in labor management safety committees. OSHA recommends that the responsibility for safety and health activities be clearly and expressly assigned to one individual. The job of this individual should be to ensure that an effective safety program is developed and implemented. However, safety and health need to be the responsibility of all employees. All employees should know that carelessness and willful disregard for safe practices may result in discipline and termination. For a safety program to be effective, all employees, supervisors, and managers must receive adequate safety training. According to OSHA standards, an employer must ensure prompt first aid treatment for injured employees, either by providing for the availability of a trained first aid provider at the worksite or by ensuring that emergency treatment services are within reasonable proximity of the worksite. Employees who provide first aid to injured coworkers are protected from prosecution for unintentional injury or wrongful death by Good Samaritan laws. All 50 states have Good Samaritan statutes that protect them from blame. Each company should examine its working conditions and potential hazards and develop a list of rules that will ensure the safety of its employees. All employees should know these rules and be required to follow them. They must be made aware of the requirements, accept them in their work, and participate actively in the safety program. Several strategies have been used to motivate employees to work safely. One of the most common methods of increasing employee awareness is a large billboard advertising how many accidents have occurred. Some organizations have safety contests in which departments compete against each other, and others have work groups where they compete against their own previous accident record. Financial incentives and other extrinsic rewards apparently can be used to reduce the number of accidents. But when the rewards become large, informal pressure not to report accidents may grow among employees. Some employees suffer serious injuries and never report them because they do not want to ruin their department's safety record. Safety incentives need to be large enough to increase employee awareness, acceptance, and participation, but not so large that employees become motivated to misrepresent what actually happens. Some organizations have found that the best way to identify unsafe working conditions and control hazards is to use a safety committee. One of the best practices is to do a self-audit. In these self-audits, we can look at safety awareness, we can look at safety practices, especially when our reports are published through the company and significant rewards or penalties are tied to the results. A helpful procedure identifying and controlling hazards is to develop a checklist of safety practices. This checklist could be used by the safety committee as it conducts periodic inspections. Supervisors and employees can also use it to take a look at their weekly or their monthly activities to make sure that everybody's working in a safe manner. OSHA has established 5 programs to work with companies in reducing accidents, illnesses, and injuries. These voluntary programs include the OSHA Challenge, Alliances, OSHA Strategic Partnerships, Voluntary Protection Programs, and Safety and Health Recognition Programs. Whenever an accident occurs, it should be carefully investigated as soon as possible to identify the causes and assess what steps can be taken to prevent future accidents. Accident reports must be completed and available for inspection. OSHA Form 301 Injury and Illness Incident Report is an accident report that records the circumstances of the accident, the nature of the accident, and how the accident was handled. OSHA Form 300 Log of Work-Related Injuries and Illnesses is a log showing each recordable accident at a work site. The 301 is actually a summary record which must be maintained for 5 years. Prior to calling it a summary record, we used to call it an executive report. Creating a safe and healthy workplace is a worthy social goal. People should not be asked to sacrifice their safety or health for any job. The intent of Congress in passing the Occupational Safety and Health Act was to require employers to provide safe workplaces. So, how well are they doing their job? Well, we know reality is that they have significantly reduced workplace accidents, thus increasing workplace profitability. Sometimes making jobs safer is to change the job up a little bit. We call this ergonomics. Ergonomics is that aspect of technology concerned with the application of biological and engineering factors to problems relating to the mutual adjustment of people and machines. This is one way of making jobs safer. The two major strategies of job redesign are job specialization, sometimes called job simplification, and job enlargement. These two strategies are almost exact opposites. Job specialization involves simplifying a job by reducing the number of elements performed by the worker, and job enlargement involves making a job more complex by combining additional elements to increase the number of activities performed by each worker. The Drug-Free Workplace Act of 1988 requires that government contractors make a good faith effort to ensure a drug-free workplace. This includes written policies, informing employees, enforcing standards, and having a drug awareness program. Workers' compensation provides income, continuation, and reimbursement of accident expenses for employees who are injured on the job, regardless of who was responsible for the accident. Before 1910, the liability for an accident was decided according to English common law. We took a look at things like the assumption of risk, the fellow servant, or the contributory negligence. However, today we have what is called a no-fault workers' compensation system. Workers' compensation is administered by each state according to its own state law and by the federal government for federal workers. Most laws simply say that they cover injuries arising out of and in the course of employment. After an injury occurs, almost all the state laws require a certain waiting period, usually 1 or 2 weeks, before compensation becomes available. Under workers' compensation laws, 3 types of benefits are provided by most states: death benefits, medical expenses, and wage replacement payments. Workers' compensation benefits are basically funded under an insurance program, and the costs to a company are determined by its experience rating. You need to know that term, experience rating, which is based on the number of payments made under workers' compensation to the employees of that company. Now, some companies have found that an early return to work policy has contributed important benefits to both the company and the injured employees. Companies not only benefit from the work the injured employee is able to perform, but the costs of rehabilitation are normally reduced and the wages paid to injured workers are largely offset by lower worker compensation premiums. Many organizations have developed extensive programs to improve both the physical and mental health of their employees. The motives for these programs are partially altruistic. Employers are genuinely concerned about the health and well-being of their employees. However, these programs also are self-serving, since managers are primarily concerned about their own health. Some health programs are designed exclusively for managers, while other programs are open to all employees. Regardless of management's motives, health programs can be justified economically. Poor health represents an enormous cost to the employers. These costs are caused by excessive absenteeism and tardiness, premature death and disability, reduced productivity, and higher health insurance premiums. Many organizations recognize the need for special programs to help employees with personal problems. These programs are typically called employee assistance programs. The performance of employees can be seriously impaired by personal problems. Professional help can increase recovery. EAPs refer employees to professional help. Employee assistance programs require careful administration. Employee assistance programs may need to comply with the reporting and disclosure requirements of the Employee Retirement Income and Security Act, or ERISA. Many organizations operate their own employee assistance programs as part of their human resource services. Large organizations are able to afford a professional staff with counselors and psychiatric and social workers. However, some organizations, both large and small, prefer to pay for the services of an outside professional organization of counselors to provide the program. Employee assistance programs are designed to provide professional assistance for employees with virtually any conceivable problem, even a small problem, if it persists longer than it should. Some problems are handled by members of the Employee Assistance Program staff. Problems that the staff is not equipped to handle are referred to professional services in the community. Employee assistance programs need to follow careful guidelines to avoid legal risks regarding privacy, malpractice, or coercion. The privacy of employees must be protected, including the confidentiality of information revealed to an EAP counselor. The value of EAPs was demonstrated in an evaluation of the Employee Counseling Services Program of the U.S. Department of Health and Human Services. Data from the program at several major sites were analyzed to determine the impact of job performance and reduction in administrative expenses. The analysis found that the program produced a 1 to 7 return after subtracting the actual costs of the program. Rather than waiting for employees to get sick and then offering assistance, many companies are taking a preventive posture by trying to help employees avoid illness and accidents. These programs are referred to as employee wellness programs because they focus on trying to keep employees well. Some employee wellness programs include physical exams to assess employee health and health education to teach proper dietary habits. Other wellness programs are designed to help employees stop smoking or to eliminate alcohol and drug use. All efforts by employers to educate and motivate employees to improve their health or to make available physical exercise opportunities contribute to healthier habits and lifestyles. This might include things like physical exams and screenings, educating employees about monitoring their own health, physical fitness facilities and equipment, self-help programs to help employees lose weight or stop smoking, nutrition classes that teach how to make fresh, low-fat, low-sodium meals and snacks, stress management seminars, maybe a website where employees can complete health assessments, and health advocacy services that help employees navigate the healthcare system and understand the services provided to the company's wellness program. A recent market survey reports that 61% of companies offer financial rewards for employees who participate in health management programs and activities, and another 21% plan to begin offering incentives in the next year. The Patient Protection and Affordable Care Act allows employers to reward employees for participating in wellness programs. However, it prohibits employers from using rewards to discriminate against participants based on health-related factors. Consequently, a wellness program cannot offer rewards for achieving measurable health-related goals without offering alternative rewards for those who cannot achieve them because it would be unreasonably difficult due to a medical condition or because it would be medically inadvisable. For example, an employee can't participate in a jogging program because of a medical condition, such as being confined to a wheelchair. Then an alternative must be provided as a way to achieve the reward. Successful employee wellness programs can be beneficial to employers because they often result in lower absenteeism, reduced health insurance costs, and increased productivity at a relatively low cost when compared to other employee benefits. It is a violation of Title VII to refuse to hire or insist on transferring a pregnant woman or a fertile woman who would be unavoidably exposed to substances creating a reproductive hazard. The Supreme Court has ruled that fetal protection policies are a form of sex discrimination in spite of the risks. Employers are expected to warn women about the increased risks of birth defects due to exposure and let the women decide whether they will be willing to take the risk. At least 7% of the adult population in the United States suffers from alcoholism. Alcoholism is a disease, a treatable disease. It is not a disease that will go away by itself. It requires treatment, usually a very confrontive form of treatment. The common signs of alcoholism are consistent tardiness, usually on Monday mornings, excessive absenteeism, accompanied by excuses of minor illness, hangover symptoms such as headaches, thirst, shaking, and procrastination, deterioration in quality of work, and off-the-job problems such as debts and family discord. Usually the jobs of these employees are the last pillars they cling to as their lives crumble around them due to problems with finance, families, and friends. With this being said, We can recognize, as supervisors, as human resources practitioners, we can recognize these symptoms, but we have to be very careful not to address these particular symptoms. They are protected by the Americans with Disabilities Act. We need to focus on only their job performance. In an effort to reduce drug use in the workplace, many employers, including about 1/3 of the Fortune 500 companies, are using drug testing to screen job applicants and, in some cases, current employees. Drug testing programs are controversial. However, employers must use caution in designing legal and defensible programs. Drug testing programs have been controversial because some people claim that testing violates their personal rights, that it's an invasion of personal privacy, and that the tests are unreliable, and that drug use off the job does not impair their job performance. Testing applicants, as a general rule, both public and private, can legally require job applicants to pass a drug test as a condition of employment if the testing program is non-discriminatory. That's really important. You either test everybody or you don't test anybody. When we talk about discipline and we talk about drug abuse and alcohol abuse, one of the most important things that we can do is to focus on job performance. So anytime there is a performance problem, an employee should be approached immediately. Supervisors should be trained to recognize the signs of drug use and especially of drug overdose. Some of these signs depend on the drugs individually having been used and may include things like slow and shallow breathing, clammy skin. So, I mean, I even hate to talk about this in a class because we're studying to take the PHR and SPHR exam. These things are so important when we teach our supervisors to look for these symptoms, that we also make sure that they understand not to accuse anybody of having a alcohol problem or a drug problem. In my career, I've seen these exact same symptoms for things like epileptic seizures, diabetic comas, employees having heart attacks. So we don't want to jump to conclusion and say, gosh, this is a symptom of drugs. But we simply want to take a look at what's going on here and then know when to take action. And by taking action, I mean when to call 911, when to call an ambulance to come get them and to take care of them. Employees need to know the employer's standards regarding the possession, use, or distribution of illegal substances at the workplace. An effective drug awareness program helps employees avoid the use of illegal drugs and know how to discourage the use of drugs among coworkers. One of the interesting conflicts that we have as HR practitioners is handling, how do we properly handle communicable diseases in the workplace? So OSHA has our general standard clause that states that employers must provide a place of employment that is free from recognized hazards that are causing or likely to cause death or serious physical harm. This standard extends to protecting employees from the danger of communicable diseases, even when that danger is presented by other employees. An employer is required to reduce the risk an infected employee might pose to coworkers and to stall the spread of the disease. This could be accomplished through education and training as well as through precautionary measures. Employers may have policies that require employees to notify the employer if they have a communicable disease that could be a threat to the health and safety of other employees. Now, things like HIV and AIDS, it's probably the most challenging health problem for employers in the workplace. Although the disease itself may not be contagious through casual contact, the fear of AIDS is very contagious for a good reason. AIDS has proven to be universally fatal. Consequently, employers are caught in the middle of a highly emotional conflict between protecting the rights of employees who have AIDS versus accommodating those who fear they will become infected by interacting with coworkers who have AIDS. People who work in service industries, especially healthcare workers, are routinely exposed to many infectious hazards, including bloodborne pathogens. The spread of HIV and AIDS, hepatitis, and other infectious diseases are forcing employers to take special precautions to protect their employees. These precautions stem from the consequences of the diseases. There is no known cure for AIDS, and some strains of tuberculosis have become resistant to treatment. Adding to the seriousness of this problem is the fact that the infectious agents can be introduced in the work environment by patients, visitors, and coworkers. A pandemic, which is a worldwide outbreak of new subtype of influenza virus that is not preventable or treatable, is a rare occurrence. Prior to the 2009 H1N1 swine flu pandemic, the last influenza pandemic in the United States was in 1918. But know the word pandemic. The environment has always contained materials that contribute to illness and disease. In recent years, however, concern has grown over the harmful effects of toxic substances and the need for concerted efforts to control them. Part of this concern stems from discoveries that some of the materials once considered safe are not so safe after all. Before germs were discovered, a public drinking cup was typically provided near water fountains for the convenience of thirsty travelers. As people learned how diseases were transmitted, however, the public drinking cups were gradually replaced with more sanitary methods for obtaining a drink. The history of asbestos illustrates how costly and destructive an environmental health hazard can be when the effects of a toxic substance are not recognized. Toxic substances are chemicals and other materials that are poisonous to the body, such as lead, carbon monoxide, and benzene. The science of toxicology is based on determining the toxic thresholds of chemicals. There is no such thing as a non-toxic material. Even common minerals and vitamins that are essential to human health are toxic in high doses. However, a basic concept of toxicology is that there is a no adverse effect level for virtually every material. This level is the highest dose of exposure that causes no ill effects. The toxicity threshold is the lowest dose level at which toxic effects can be demonstrated. Employers are required to identify areas in the workplace containing ionizing radiation hazards associated with the release or presence of radioactive materials or other sources of radiation. And so if you move over to page 48, it talks about some of these things that we don't really give much thought to. Things like our computers, video display, etc. The mental health of employees is just as important as their physical health. A highly stressful working environment can be just as destructive to mental health as toxic substances are to physical health. Unlike physical health, mental health is not protected by the Occupational Safety and Health Act. In some instances, however, employees can receive workers' compensation benefits for physical or mental breakdowns caused by the cumulative trauma of an excessively stressful job. So some of the things that are challenges in the workplace include things like boredom, burnout, anxiety, and depression. When a stressor is present, a sequence of biological events occurs. We have 3 stages. One is called the alarm reaction. That's that fight or flight syndrome. The other is called resistance, of course. And then we have exhaustion, and that's where the body just exhausts itself to adapt, with the ability to adapt. Coping strategies are to eliminate the stressor, use relaxation techniques, and try some transcendental meditation. Biofeedback is another relaxation technique, as well as a social support system and or physical exercise. Exercise enthusiasts argue that the best technique for managing stress and maintaining good health is a regular program of physical exercise. Although these claims may be overstated, an enormous number of studies have shown that a well-designed physical exercise program can significantly improve both physical and emotional health. Many companies provide an on-site medical care by hiring healthcare providers and furnishing them with a clinic on the company's premises. Since 1980, the number of companies with policies limiting smoking in the workplace has increased from less than 10% to about 90%. In earlier years, the role of security for corporate America was performed by public law enforcement. The local police were expected to protect the assets of companies. In recent years, the role of public law enforcement has diminished because security breaches have become more frequent and costly, and local law enforcement agencies have not been able to adequately protect companies. Civil litigation has also become slower and more cumbersome, adding to the need for companies to protect themselves. The responsibility for security is assigned to the Human Resource Department in most small and medium-sized companies. But as companies become larger and more vulnerable to thefts, they are more likely to establish a separate security department. And even then, security may report to human resources. I know in my case, I always had security and loss prevention reporting directly to me. So some of the things that are involved when you are heading up the security organization is doing a vulnerability analysis, proper planning, establishing roles and responsibilities, evaluating, looking at liability limits, protecting your employees against things like kidnapping, and then security anytime we're doing any type of transportation. Control systems include physical security, disturbances, being prepared for disturbances, parking and traffic issues, your entry and exits, signal detection theory, and electronic security devices. And you should probably take an extra look at the signal detection theory, only because I have heard there was a question about it on the last exam. There are several laws that have to do with privacy protection in the workplace. I would like for you to take some time to go through and understand what these laws are. Look at them from a historical perspective, then bring them up to date. So we've got the Common Control Act, the Fair Credit Reporting Act, the Privacy Protection Act, Polygraph Protection Act, Health Insurance Portability and Accountability Act, that's HIPAA, and it's huge. If you've been to the doctor in the last 5 years, you know how important HIPAA is. Federal Wiretapping Act, Investigative Consumer Report, and the USA Patriot Act. Employers who have important or sensitive information stored in computers should have a security system to protect this information. Companies use firewalls to reduce the danger of security breaches that could occur as company-sensitive information is accessed via the internet. There is a list of bullet points for industry guidelines, which is provided to us by the computer industry, and they have specific security guidelines that they recommend. So make sure that you review that. Exit interviews indicate that a significant percent of departing workers take some form of proprietary or confidential data with them. This is called data theft. A patent is a grant from the government of the United States giving the inventor the right to exclude others from making, using, or selling his or her invention. A trademark is a word, phrase, symbol, or design that identifies and distinguishes the source of the goods or services of one party from those of others. A copyright is defined as the exclusive right or privilege of authors or proprietors to print or otherwise multiply, distribute, and sell copies of their literary, artistic, or intellectual creations when the copyright is obtained in compliance with the copyright statute. Part of an employer's obligation to provide a safe and healthful work environment is to ensure that the company has an emergency preparedness plan for handling such emergencies as fires, explosions, earthquakes, chemical spills, and acts of terrorism. Although some companies have comprehensive plans for what to do in case of emergencies, most companies only have partial plans and their employees have not been adequately trained on how to respond to crisis situations. It's difficult to anticipate all possible emergency situations, and each crisis could call for a different response. Extreme weather, emergency situations, fires, terrorist acts, all require very different training. However, employees can be trained to respond to general emergencies and can also be given specific training to deal with scenarios that are more likely in their area. Companies with employees who live in or travel to foreign countries, especially countries with higher levels of terrorist activities or political unrest, must have plans for protecting their employees. Workplace violence refers to any act taken by an employee that undermines the purpose for which an enterprise exists. Assault, criminal mischief, disorderly conduct, harassment, larceny, menacing, reckless endangerment, robbery, and sex offenses, and of course, murder. Terrorism is the use of force or violence against persons or property in violation of the criminal laws of the United States for purposes of intimidation, coercion, or ransom. A serious disciplinary problem for all organizations concerns any form of illegal or dishonest behavior, including theft, embezzlement, misuse of company facilities, or falsifying records. Statistics show that such dishonest acts have increased dramatically in recent years. White-collar crime is not always in the form of employees stealing from the company. Many white-collar crimes are committed by the top corporate officers on behalf of the company. According to the Association of Certified Fraud Examiners, organizations in the United States lose 5% of revenues each year to fraud. So it's important that when we are working in human resources, we have a good, solid investigation procedure so that we are able to uncover these types of issues. One of the terms that you need to know is called loss prevention. In retail stores particularly, they measure their losses in terms of inventory shrinkage, which refers to the amount of inventory they actually have relative to what they should have based on the inventory they purchased and what has been sold. So we have something called honesty tests that can be provided to determine whether or not we are actually hiring people who are honest. Extensive research has shown that some of these instruments not only produce reliable information that validly predicts dishonest behavior, but that they also are free from biases of age, race, and sex. These honesty tests represent a valuable selection tool for choosing employees who will occupy positions that involve handling money. You also want to make sure that you have good, solid internal financial controls, which include checks and balances. Now, under the Federal Sentencing Guidelines for Organizations Act, companies can be held criminally responsible for fraud perpetrated by their employees. This agency regulation, which became effective in 1991, was updated in 2004, applies to virtually all U.S. businesses and organizations, and increases corporate penalties for violations of federal law. However, it provides potential relief in the form of reduced likelihood of prosecution or lower fines for companies that establish and implement effective programs. Employees who are terminated for misconduct are not eligible for unemployment insurance. Nevertheless, these employees frequently apply for unemployment benefits by claiming that they were simply laid off. And companies that have decided not to let them get the benefits can appeal the case. Because appeals are unpleasant and usually take considerable time and effort, many companies choose not to contest them. However, this negligence contributes to higher experience ratings, which increase future premiums. Don't forget to email me at info@trademetoday.com or call me at 951-926-2644 or post your questions on the website. This concludes this lecture.